Hi there, my name's Mitchell. I'm an immigration attorney with the dual specialty of the EB-5 investor visa and immigration court removal proceedings litigation. It's kind of a weird mix, but unfortunately, it's something that's becoming more and more common. This video is going to center around EB-5, but it could apply to pretty much anyone who's on an employment-based visa. But I'm just going to give a little background. It's March 2026 right now, and USCIS has been very aggressive in their adjudication when it comes to source of funds review. I'm not going to get too into it, but if you've been following the general EB5 news, you might know that regional center affiliated loans have been a pretty big target. Currency exchange, particularly from China, has been a pretty big target. And even just things as simple as changing your source of funds when you're doing interfiling, that's also been a bit of a target, even though you're using funds that are still legal. For whatever reason, USCIS has an issue with that, which I strongly disagree with. But unfortunately, when you are denied at the 526 or 526E stage, then you will probably soon get an I-485 denial. And if you end up appealing, then maybe you have a chance. But if you get both the 526, 526E, and the 485 denial, and you don't do anything about it and you remain in the US, then you could end up receiving a notice to appear in immigration court. We call it an NTA. Basically, it's a document listing a series of allegations, not much too serious, just kind of encapsulating when you entered the US, where you're from, who you are, and in this case, that you overstayed. There will also be a charge of removability. Typically, in this case, it would just be overstay for people who were on the EB-5 process. Now, this might not happen to every single person that gets a denial from USCIS. For example, if you kept your underlying legal status and it's still valid, for example, if you were H-1B or maybe on an L visa, then it wouldn't really lead to an NTA, or at least it shouldn't, unless DHS makes a mistake, which, we know that they never ever do, supposedly. But getting straight into it, the notice to appear will give you a date to appear in immigration court. Depending on the court, you might be able to show up virtually, which is obviously ideal, or you might have to show up in person. But before you even get that date, it's best to hire an attorney who can really do a few different options for you depending on where you are. If you are wrongfully placed in removal proceedings, let's say that you were able to refile a new 526E petition with a 485 and you didn't face any sort of bars, maybe on INA 245K. Now that's a whole other rabbit hole to get down, but hypothetically USCIS sent you this NTA and they shouldn't have, then you can proceed with a motion to terminate the removal proceedings. Judges don't always review right away, but you can send this to the Department of Homeland Security attorney, who's kind of like the prosecutor to your immigration attorney being basically like a defense attorney. And you can try to get them to agree to the motion to terminate and then send it to the judge. And I don't know how other attorneys do it, but I oftentimes call the immigration court when they're taking too long and tell them to hurry up. Not always successful, but sometimes it works. That's a great way to just get rid of the case before it even starts. You don't have to worry about accruing the over 180 days of unlawful presence, which could be an issue later when you're trying to adjust. Another option is simply to request voluntary departure, which allows you to leave the country. Once again, if you're able to do it before 180 days of unlawful presence has elapsed, then it keeps you from having to deal with the 1 to 3 year ban. It's an option that I've done for some people who didn't really have a good argument to terminate the removal proceedings. Not super relevant, but there used to be another route, which was asking for prosecutorial discretion, where you would make a deal with DHS to basically no longer prosecute the removal proceedings. They used to do this under Biden, but they're not doing it under Trump. What else? There's another option too. You can try to get the court to administratively close your removal proceedings, which might be more and more likely if you go for termination and it's denied. You can also make a motion to administratively close your case, especially if you are now once again pending your I-485. It's a little bit of a delicate process. You just want to show that you are actively pursuing, probably in this case, the investment visa, but again, it could be other options as well, so long as you qualify. When it comes to immigration court, generally it goes master calendar hearing. That's the first hearing you're scheduled for, and it is just a scheduling hearing where your attorney comes in and makes the pleadings on your behalf. This is also where they can argue to the judge that, hey, this case should be terminated, or hey, we're just seeking voluntary departure, or in kind of rare circumstances, you request the individual hearing. That is usually scheduled anywhere from a couple months to a couple years out, and that's where you actually litigate your immigration case. Now, this will not typically apply to those who are denied during the I-526 EB-485 stage, unless you have a new form of relief, something like asylum, maybe a cancellation of removal case, if that applies to you. However, could be a little tricky in today's day and age. It really is case specific. Now, the other kind of people who are pursuing EB-5 are those who get denied at the I-829 stage. That would be a very long video to make. I've spoken about it before. However, yeah, I'm not going to get into it now. Maybe I'll make that a part 2, how to deal with litigation in immigration court at the I-829 stage. And there's not really too much else to know aside from if you think USCIS is being difficult and harsh, the immigration courts are even more so. So it's important to retain an attorney early and to move quickly. And if you see an NTA or you see that you have an immigration court case, but it's scheduled very far out and you just don't want to deal with it now, you want to focus on other things, think again. You want to act quickly. These dates can be changed, and you might not see it, and then suddenly you might end up missing your immigration court hearing and being removed in absentia. Now there's other options you can go to from there, such as motion to reopen. And then, of course, if you are ordered removed, you can always appeal. You appeal to the Board of Immigration Appeals, the BIA. They can, basically, you have 30 days to do so. If you get denied from there, then you can go to the federal immigration court. But again, this mostly isn't going to apply to those denied at the 526E stage or the adjustment stage. So if you have any questions about this, I'm going to put the link to contact me below. Hopefully this video was helpful to you. And I wish you best. All right, thank you so much.